Over the last 72 hours, federal agent shootings in Minneapolis have ignited a nationwide legal and civil rights debate. These incidents are not just about one city or one operation. They cut straight to the heart of American constitutional law. When federal agents use deadly force in civilian neighborhoods, the consequences ripple far beyond the individuals involved. They raise urgent questions. Who sets the rules for federal agents? What rights do ordinary citizens have in these encounters? How does the Constitution apply when enforcement turns deadly? And most importantly, who can be held accountable? Today, we break this down clearly, legally, and without political noise, so you understand what U.S. law actually says. Federal law enforcement officers, such as ICE, DHS, FBI, or U.S. Marshals, derive their authority from federal statutes and the U.S. Constitution, not state law. This gives them nationwide jurisdiction, federal immunity protections, authority to operate inside states. Even without local approval, however, federal power is not unlimited. Every action they take is still constrained by the Constitution. That is where the Minneapolis shootings become legally significant. Constitutional Rule, Fourth Amendment. The Fourth Amendment governs all use of force by law enforcement, state and federal. Deadly force is constitutional only if a reasonable officer would believe there is an immediate threat of death or serious bodily harm. This is known as the objective reasonableness standard, established by the U.S. Supreme Court. Key points. Intent does not matter. Political context does not matter. The officer's belief must be objectively reasonable if a suspect is fleeing, unarmed, or contained. Deadly force becomes legally suspect. Beyond the Constitution, federal agencies impose internal rules that are often stricter than state police standards. Most DHS and DOJ policies require exhaustion of non-lethal alternatives, clear articulation of imminent threat, no deadly force solely to stop a vehicle, no deadly force to protect property alone. Violating internal policy does not automatically mean a crime, but it strengthens civil liability and disciplinary action. Many Americans believe federal agents operate outside constitutional limits. That is legally false. Citizens retain Fourth Amendment protection, unreasonable force, Fifth Amendment due process, First Amendment rights, speech, protest, observation. Federal agents cannot use force as punishment, detain, without lawful authority, retaliate against speech or filming, even during immigration enforcement. Constitutional rights remain intact. A federal shooting becomes a civil rights issue when the threat was exaggerated or non-existent, force continued after danger ended, victims were unarmed or compliant, agents acted outside lawful objectives. Courts analyze video evidence, witness statements, agent reports versus physical facts, whether alternatives existed. This is exactly why the Minneapolis cases triggered judicial scrutiny. Federal agents almost always assert qualified immunity. This doctrine protects officers unless they violated a clearly established constitutional right that any reasonable officer would know. This is why many civil rights cases fail, even when force appears excessive. Courts ask, was there prior case law with nearly identical facts? Was the violation obvious beyond debate? This is a high legal bar and one of the most controversial doctrines in U.S. law today. Yes, but rarely. Criminal charges require proof beyond a reasonable doubt that the agent knowingly violated the law, the use of force was unjustified, the action was willful. Not mistaken. Most cases end without criminal charges, even if civil liability exists. States cannot arrest federal agents acting lawfully, but they can sue. Legal pathways include constitutional challenges, Administrative Procedure Act, lawsuits, federal injunctions, evidence preservation, orders. Minnesota officials have already pursued legal action alleging excessive force, constitutional violations, overreach of federal authority. This creates federal versus state legal tension, a recurring theme in U.S. History, wrongful death claims. Can families sue? Yes, but not easily. Federal Tort Claims Act, FTCA, families may sue the U.S. government, not individual agents, for wrongful death negligence excessive force limitations. No punitive damages, strict deadlines government defenses, apply civil rights, lawsuits personal lawsuits against agents face. Qualified immunity narrows Supreme Court precedent judicial reluctance to expand liability success is rare, but not impossible. These shootings are not isolated incidents. They test limits of federal enforcement, power meaning of constitutional protections, accountability for armed authority public trust. In law enforcement, every court ruling sets precedent that shapes future enforcement nationwide. The core legal question is simple but powerful. Can the federal government enforce the law without violating the Constitution? American law demands both enforcement and restraint. When force overwhelms restraint, courts must step in. Possible outcomes include federal internal investigations, civil litigation, settlements policy, changes court rulings clarifying use of force standards regardless of outcome. These cases will shape future federal operations. Federal agents are powerful, but not above the law. The Constitution applies. In cities at night during arrests, even in chaotic moments, the Minneapolis shootings have reopened a national legal conversation, one that defines the boundaries between authority and accountability in America. If you want clear, legal breakdowns of the most important U.S. cases shaping American law, subscribe and stay informed, because knowing your rights is the first step in protecting them.